right? February 7th. The first item on the agenda is the approval of minutes. Do I have a motion on the approval of minutes for January 27th and 29th? Representative Johnson?
So moved.
And Representative Neighbor seconds. Thank you very much. All in favor? Aye. Okay, good job. And any opposed? Okay, thank you very much. That is taken care of. Next, we will open the hearing on House Bill 2175 to give us a summary and overview. Jesse Pringle from the Revisor's Office.
Thank you, Madam Chair. Good afternoon and happy Red Friday, everyone. So today this bill briefing is on House Bill 2175 as introduced. What this bill does, it proposes new sections of law and amends current statutes related to investigations of abuse and neglect that are conducted by the Secretary and when law enforcement agencies may take a child into custody. So there are new sections, which include Section 1. Section 1 is when a child is the subject of an investigation or has been taken into custody by law enforcement, the parent should be provided a written and a verbal notification of that parent's rights and with information regarding the process. So that written statement under Section 1 would include procedures for the investigation, describing when a joint investigation between law enforcement and the Secretary would occur, that the person has the ability to file a complaint against the Secretary, how to access governing laws and regulations on the process, warns that statements that may be made may be used in the proceedings ahead, if there are to be any, that the person has right to legal counsel, how the person may access the child, and encourages recording of interactions. Then the verbal notification that is required to the parent is that they have a right to counsel and they have a right to record interactions. And this section also states that the verbal notification is to be provided in a language that is understood, and then the written statement has provisions related to readability on the point type and language as well. So this section would then require the Secretary to develop these materials for these two written statements and then share those prepared materials with law enforcement so that law enforcement can also comply as they are required in the section, and then also requires the Secretary to post these materials on a public website. Section 2 would allow for an agreement between the parent and the Secretary when an investigation of abuse or neglect is occurring, and that agreement would concern duties of the parent and the Secretary in the instance, outline when a parent may visit and how to communicate with the child, the agreement's expiration and other terms deemed necessary between the parent and the Secretary. This agreement would last for 30 days, but there may be a possibility for another if agreed to by the Secretary and the parents. Lastly, the Secretary must devise a plan for the safe return of a child if that is determined to be the outcome with the parent if one of these agreements are entered into. So that would be a following requirement if parents and the Secretary enter into the agreement allowed and authorized by Section 2 of the bill. Section 3 is where we get into the statutes that are being amended. So Section 3 amends 38-2217. This is a statute in the code regarding health care decisions of a child. It amends the very first subsection that no consent is required when a child is alleged to have been abused or neglected to add in the phrase in the custody of the Secretary. So this section is amended to include a court order process when that consent is not provided. So the court is required to finding a probable cause that the release of medical records or conducting an exam or procedure would actually protect the child from abuse or neglect. And the court, upon that finding, may order release of records or for conducting that exam or procedure. As far as the findings in the order go, the order itself shall not be ex parte unless it would otherwise endanger the child, and then a copy, if requested, may be provided to a party to that proceeding. Section 4 is KSA 382226, and this is the statute in the code that governs investigations. So this adds a new language in subsection H. The committee may be familiar with subsection H. This is in the past couple of years, a recent development that requires visual observation of a child. So a visual observation of the child when an investigation is being conducted. The language that is added by this bill is that such observation would be conducted at the beginning of an investigation. Current statute does not have a time period in which this visual observation is required. And then that section also has a new subsection J that would require the secretary to complete a final written report of an investigation of abuse or neglect and include that report in the child's file. I think this is the last section. Section 5, KSA 382229, is a little bit like the health services and medical section earlier in the bill. This talks about disclosures and subpoenas for information. So this allows a court to order access or disclosure when the court has probable cause that a child has been harmed, probable cause that a child is a missing person, court has reasonable suspicion that a child is a victim of trafficking, and the court has reasonable suspicion that a child is experiencing a behavioral health crisis and that child may cause harm to self or others. Similar to the healthcare statute, these findings, or this order shall not be ex parte unless it would otherwise endanger the child. The findings must be made by the court with evidence, and a copy may be provided upon request of a party. With that, if this bill were to be enacted, it would be effective upon publication in the statute book.
Okay, thank you very much, Jesse. So let me start with saying I am the requester of the bill. I understand that, but I'm not offended, okay? This is a starting point. This is for discussion, so I am open. You're not going to offend me with statements that are going to be said. I just wanted us to start somewhere, and it's easier to start with a bill than it is to start with an idea. So this is what we're starting with, and I fully expect this to be amended if it comes out of committee. So with that, are there any questions for the reviser on this bill? Representative Page.
Yes, Madam Chairperson, those forms that you talked about, does every county or whoever has the jurisdiction, are they uniform? Will they all be the same, or they create their own? I didn't know.
Yes, so under the section requiring those forms, the secretary would complete all those forms and then distribute those out to the employees of the secretary and contractors, and then also supply that to all law enforcement agencies. So it would be the idea that all of that would be uniformly distributed.
Does that person have enough time? If you're saying the date you gave, if it passes, then they need to have all that stuff together prior to, so.
Yeah, so the bill doesn't have a date in it in which the forms need to be completed, but if it is passed and signed by the governor, in April when session, then an agency and has a few months until it goes into effect on July 1st. So they would be apprised that that would be going into effect.
Thank you, thank you.
Representative Neighbor.
This may be a question for you since you talked about the bill real quickly. Did this come from another organization, or is this a template from another state or a recommendation or something that's been enacted?
So the base bill is from Texas, and I did make a few changes there when I submitted it to the reviser, but it is the base bill from Texas. So we need to make it right for Kansas.
Thank you very much.
Representative Roser?
Hi, thank you, Madam Chair. Parents of a child is subject, notifying the parent of a child, would that include parents who are temporary legal custodians or temporary legal guardians of foster children?
Yes, so since this would be a part of and supplemental to the code, it would pick up that definition of parent in 382202, which includes legal custodians.
Thank you.
Any other questions for the reviser? Representative Humphreys?
Actually, maybe it's for you, but I don't have a copy of the bill, and I'm not seeing it. I'm seeing the bill brief, but not the copy of the bill. Okay, everybody got one? You got your own.
I printed my own.
Was that put on the S drive, the bill?
Copy of the bill? No, but it's on the KS Legislature.
I can find it. Okay, just wondered. All right, thank you.
Okay, other questions for the revisor or me? Okay. Thank you, Jesse, very much. Okay, so we are going to start with proponents, of which there are none, so I will say that. And I'm really not offended. It's okay. And then opponents, we'll start with them. I'd like to welcome Ed Klump back to committee. If you'd state your name and the organizations that you represent, that would be great. Thank you.
Thank you, Madam Chair. Ed Klump, and I'm here representing the Kansas Association of Chiefs of Police, Kansas Sheriff's Association, Kansas Peace Officers Association. I'm getting old. I can't hardly get that out in one breath anymore. So we are here in opposition to the bill, but I'm glad to say we're going to talk about some things we like in the bill too. So we'll give you that, okay? So I want to start just at the beginning of the bill with new section 1. This entire section seems to almost be entirely information about DCF processes. And it doesn't seem to us that law enforcement's the one to be delivering that kind of notice. There's other complications I want to talk about with us delivering notice like described in this bill as well. But we believe that if there are things that we really need to give people, then that needs to be in a separate section of the bill, so we isolate those things that have to deal with the DCF process and what deals with our process. And we'd be glad to work with anybody on looking at what would be appropriate to do that and what might be difficulties in doing that. So I want to jump down to page 1, line 23. And one of the things that has to be in this packet of information is a summary, a written summary, but it doesn't say what the summary is supposed to be about. So we need to clarify that somehow. If the summary is about what brings us to this point of having contact with you, that may work for DCF, but for us, we oftentimes don't make the contact knowing that we're going to be engaged in this type of activity. And so we're developing what leads us to be in a discussion about the welfare of the child, not knowing we're getting into that when we knock on the door. And so that would be very difficult to us to produce some written summary before we contact the parent in those cases. So just want to point that out. Also, if we were to do that, and I don't know, again, if this is an issue with DCF, but it certainly is with us, our experience is you don't want to give too much information about what you know when you start these conversations, because you thwart the investigation when you do that. Generally, we learn a lot from people when they don't know what we know, because they assume we know more than we do sometimes. And so that's an important component of any investigation. So we don't want to put too much information out there that would thwart that on the law enforcement side. On lines 25 and 26 of page 1, written or read aloud in a language that such parent understands. Well, first of all, there are 13 different languages that are commonly spoken in the homes in Kansas, 13 different languages. I can tell you that I will struggle doing it in English. I certainly cannot do it in any of the other languages. And so that provides another obstacle, even if and it does say printed or verbal, but then we've got to have some printed document available in all those different languages. So again, it may work for DCF because they can prepare for that visit, but for us, when we walk into these situations, we can't be carrying around 14 different versions of this packet of information and expect every officer to have it every time they go on a call, when they may confront these types of calls maybe once every 3 or 4 years in some of our rural areas. So that's a real challenge for us. We're familiar with the complications of reading things to people because we have to do that in DUI arrests. This is different than reading Miranda. That's pretty short and simple. But even in Miranda, people tend to not want to hear it. And so they do things just to keep talking, making noise and things like that. And so we're like reading it to the wall. But when we get into lengthy documents like this, and an example of that is the DUI warnings that we have to read, and they're much shorter than this will be. People don't listen anyway, and all they do is they want to argue with you on every point as you go through it and everything. And so it's impractical to think that we're going to read this clear through in a large document like this, and it's especially impractical to say we're going to read through it in a foreign language. And so what we do with foreign languages is we have interpreter services that we can call and do that, but they're not going to have this form set in there. So you're going to be working with an interpreter that doesn't have this form, so you're going to have to read it in English, then they're going to have to say it in a foreign language, and it's going to be a mess. And oftentimes, when we're confronted with that, we just stop, because we don't have the resources out in the middle of the street to do that. So we just stop and we do whatever we need to do to take care of the matter, and then when we get in a setting where we have time to get the interpreter, then we can do that. So those are all issues in that first section. I'm going to jump to section 4. And line 7 on page 9, the addition of those words "as soon as possible." Thumbs up. That is a great addition to this. This allows us some variance in the time frame, but still makes it urgent that we get it done as quickly as we can. And so I appreciate that. If you flip over to the top of page 2 of my testimony, though, we have an ask for you, and that is to add another provision to this, because this is something we run into frequently, especially along our border cities. We ask for your consideration to add language stating that if the child is known to be in a location outside of the state of Kansas, a request to a child welfare worker or law enforcement agency of jurisdiction in the other state satisfies the requirements of this provision. Right now, we don't have this. Right now, what this statute really says is we, as the investigators, must lay eyes on this child wherever they're at, meaning we are supposed to go to another state and try to find them. And that's impractical. It's been an issue that our officers ask us about all the time on this. And typically, this is what we do. We call the other state's welfare agency, or we call the other state's law enforcement agency and say, we have this complaint on this child. Will you please go by and check the child and get back with us? And I'll be quite honest with you, some places will do that routinely. If you try to get them to do that in Chicago or in St. Louis or Dallas, you're probably not going to get an answer from them. So it works sometimes, but it doesn't. And we want to be in compliance with the law. In new subsection J on page 9, line 25, we would ask for a consideration of adding a requirement that any law enforcement agency that has been involved in a joint investigation be notified by DCF when they close a case. That's been an issue with some of our investigations. DCF closes a case and we're not aware of it. So we just ask for something to be put in there that we would be notified. And then if we jump to section 5, page 9, line 32, there's an issue that comes up here that we don't have a tool to address, and that is if we have a parent, this is especially true of a preschool child. If we have a parent who says, no, you cannot see my child, we have no legal authority to force our way into that home or place to look at the child. We have no legal authority to do that, short of an exigent circumstances where we have probable cause to believe that somebody's in immediate danger, and that's not present yet in most of these cases. One of the things we need, and this needs to be vetted with the prosecutors yet. I did not have time to do that yet. But we need something like in the statute that authorizes courts to issue a search warrant for us when we have probable cause a child is a victim of child abuse or neglect, and probable cause that child is in this location. We can go in and search for this person, namely the victim, the child, and lay eyes on them and make sure they're okay. We do this for people all the time. People don't think about search warrants for people, but we do it on a regular basis when we're looking for a suspect or we're looking for a person with warrants. So it's not out of the question. But the language, the current language in our search warrant statutes don't have this listed as one of the things that a court can issue a search warrant for. And again, this hasn't been vetted with the prosecutors, and we need to do that to make sure we get this right. So the other thing that I just want to point out to you is the provision about, some places it says in here about not interfering with an investigation. Where's that at?
Jesse, if you can help him.
Line 32 and 33 on page 9. I noticed that this doesn't have any penalty provision to it. Now, for us, that's not a problem because there is a general interference of statute for law enforcement. So if we are conducting an investigation and somebody interferes, we have a criminal penalty, a criminal law with a criminal penalty that we can use. But your caseworkers, there's no sanction for this. So we're saying you can't interfere, but there's no penalty if you do interfere. So you might want to just kick that around and see if that's necessary from a DCF's perspective. And with that, I will stand for questions.
Okay, thank you. Other questions, committee? Representative Johnson.
Thank you, Madam Chair. Chief, one of the issues that I think law enforcement has run into is that many of the complaints asking for a check of a child's welfare are anonymous. And aren't we required under search law requirements to have some form of reasonable proof that the person is reliable, yet our other statutes are in conflict with that, and so it's not released?
You're absolutely correct. So here's what the courts have said on that, and where we run into it is, well, what the courts have said is, for example, if we are authorized by law to stop and detain any person who we observe when we have reason to believe they are committing, have committed, or are about to commit a crime, okay? So the case law on that is, and this is a reason to believe level, we cannot make that stop on reason to believe on an anonymous tip. Now, if we have an anonymous tip and they say there's a guy in a brown jacket and a red hat selling drugs on the corner of 5th and Main, and he drives a white Toyota, and we go there, and there's a guy matching that description, that verifies at least some authenticity of that tip that we've received. Now, it doesn't authenticate that they're selling drugs, but at least we know that part of that information is true. So in this case, we get a call of a complaint that a child is being abused or neglected, and we see no other evidence of that ourselves. That is not enough to act on even under reasonable suspicion, let alone probable cause. So yes, even to get a search warrant, we're going to have more than just we got this anonymous complaint. Does that answer your question, sir?
Yes, thank you.
Do you have any other questions?
No, thank you.
Okay. Any other questions for Mr. Klump? Okay, I have one question.
Okay.
So, actually, I have a couple. Jesse, if you could just clarify the word summary on that first page for us.
Sure. Thank you, Madam Chair. So on that first page in line 23, a written summary that, and then AB describes how that summary is to be provided, written, read, but then C is what contain the information to be contained. So that summary includes all of I and then the following as far as the information that is to be in that written summary.
Okay, okay. I didn't put that together, thank you.
And then on line 24, page 1, it says brief. So it's not meant to be a long, drawn-out statement. Is that the way I'm reading that? Is that correct?
In line 24, it says a brief and easily understood. Yes.
Perfect, thank you. And then just to clarify for me, so search warrants are not currently used in child welfare, or?
Well, they could be, I suppose, in some circumstances if we have identified probable cause for a criminal act to occur.
It's not common.
But in this case, there is nothing that I found anyway in the statutes on search warrants that would authorize a search warrant to be issued just to check the welfare of the child.
Okay, interesting. Jesse, do you know anything about that? Okay, thank you. We'll follow up with that. And then two more questions. When you currently read a Miranda warning to a criminal that's being arrested, do you use different languages? Or is it just in English?
Well, the answer to that is you've got to give Miranda in a way they can explain it, or you stop doing the questioning. People have a lot of misunderstandings about Miranda. So the short answer is, if we can't give it to them in a language that they understand, then it's not an effective warning. Keep in mind that a lot of times when we stop certain people that know a foreign language, that's all they know until they're talking to their bondsman and they speak pretty good English. And so, but we have to go on what we are aware of at the time we give that. So basically what's going to happen is we're just not going to ask any questions. There's a lot of misunderstanding about Miranda. A lot of people think we need to give a Miranda warning anytime we stop somebody or arrest them. That's not the case. The only time we have to give Miranda is when we are going to be questioning them as a suspect and they are not free to leave. So those Miranda warnings aren't done like this would be right at the beginning of a conversation. They rarely are.
And this is just like, I think people are familiar with the word Miranda. That's when we call it the Miranda style bill, because it's just stating the rights of a biological parent.
Briefly.
Yes.
Stating rights.
Briefly stating rights, correct.
Yeah.
I was just curious if that was common practice, because we do have that in a language that can be understood, if that was something.
So if you have something in statute, I believe, and one of the other conferees may have more legal mind than I do to answer this, but it seems to me that if you put in there, you have to give this warning before you talk to them, and you can't give it in their language, you're not going to be able to talk to them.
Okay, and then my last question, if we were to amend this bill to take out the law enforcement aspect in section 1 and then work on your changes that you suggested, would that switch you to a proponent? Possibly?
Yes, I believe, the other things in that, if law enforcement was taken out of that, we would have no issues then with section 1 as far as the information we need to provide.
Thank you. Any other questions? Oh, Representative Johnson.
Thank you, Madam Chair. Chief, you said 16 languages in Kansas. 13.
That's not counting English.
I guess I would challenge that as very understated. I know for a fact when I been to 2 of my schools, ESL classes at Piper High School, or their elementary, I think we had 23 languages. I'm going to be pretty sure for my old high school Wyandotte when I was there, far more than 13 languages and or dialects. And there is absolutely no way. So
let me tell you where I got that information. Mm-hmm. One of the questions in the census, the U.S. Census, is what language is spoken in your home? And that's the answer that this information comes from. 13 languages are the primary language spoken in the home.
Okay,
That comes from census. Accuracy?
that the
No idea.
I would challenge their accuracy because I put down Swedish and I don't see that anywhere.
Yeah.
So thank you very
There is
much.
an other category in there.
Thank you.
Okay, any final questions? Representative Page.
Thank you, Madam Chairman. I don't have a question, just a comment. We have 162 languages in U.S. District 500.
Oh, wow. Wow.
It's more than.
Yeah. Yeah.
Wow.
Yeah.
Okay, any final questions? Okay, thank you very
you.
much, and thank you for the input. Next, our next conferee is an opponent, and he is on WebEx. He is my district attorney. I'm trying to butter him up a little bit. Mark Bennett from the 18th Judicial District. Mark, are you there?
I am. Can you hear me?
We can, thank you.
Well, thank you for the time to speak on this. I will jump on the last comments there. I think there's a distinction between languages and dialects of languages. Chinese is a language, but there are Cantonese and there's any number of dialects that come within that. And so I think that's where maybe some of the distinction is. It's a minor point for me, but I know that is an issue at times because we'll have to interview people and they may speak different languages. We may get somebody in who's a Spanish speaker, but we're talking about somebody who comes from a different part of Latin America and they may speak Spanish, but they have a hard time communicating with our interpreter because they come from a different part of from a different country maybe and have a different dialect. So anyway, not hardly the point of my conversation, but I thought I'd at least add that. Last night, Representative Howard and I spoke at some length about this, and I think we both understand each other's positions a little better. I'll add this. I think that as an overarching first level concern, threshold concern, I think we need to make a distinction between situations in which either law enforcement, as the bill's written, it would be law enforcement or DCF. It would apply to both. I echoed Ed's comments a moment ago that if we could remove law enforcement from the scenario and from this, that would help considerably. But I think the larger issue is what kind of cases are we talking about here? Negligent cases or cases where there is maybe services haven't been provided, food's not been provided, there's something going on, as opposed to there's been harm to the child or there is an absolute identifiable risk to the child. I think those are two different universes because I'm here because the kid's been missing school. This bill might apply to that scenario. I'm here because the kid's running around all day and night and I don't see anybody really paying attention to him, or you need services, things like that. I understand why there may be some desire to make sure that parents have more information up front, et cetera. But if I'm there because the child just arrived at the emergency room with broken legs or broken, eye orbit, or comes in claiming or complaining of sexual assault, we're squarely in the realm and the universe of criminal investigation. And in my mind, this bill has no application there. And I would be very much opposed to trying to cobble these things into that. And I don't want to put words in anyone's mouth, but I think there's an understanding and there's a recognition that those two things need to be distinct and that we shouldn't muddy the waters between the two. As to some other earlier questions, can we get a search warrant? No. I can't get a search warrant for a negligence claim. I want to be real clear about this because I think people hear this in other states and they maybe conflate what's going on in Kansas. There is no negligence crime in Kansas. We don't have the crime of negligent homicide. I don't have the crime of negligent battery or negligent abuse of a child. We have intent, reckless, and knowing. Those are our three mens rea, the mental state necessary to commit a crime. Negligence is not on the books in Kansas for a criminal case. So if there's an allegation that mom and dad haven't been feeding the kids as much, but not because they've been withholding it intentionally, but they're just, they have a lot of, they're down on their luck and they don't have enough food in the house. There's no crime unless we go so far as to the realm of what's called endangering a child under KSA 215601. And that's defined as recklessly causing or permitting a child under 18 to be placed in a situation in which the child's life, body, or health is endangered. I don't think that we're talking about these scenarios. I don't think that's what the concern is that gave rise to this bill is talking about. We're not talking about recklessly, putting a kid in a situation where their life or their health is endangered. We're certainly not talking about situations where someone has intentionally, knowingly abused a child, hurt a child, sexually assaulted a child. So if we're on the same page there, then I'm not going to waste a lot more time talking about why this is a bad bill, because it might affect criminal investigations. If there's an understanding that no, that's not the intent, then I think we're closer to being on common ground. I would say that the upon first contact that's set forth in the statute, or the proposal, rather, the bill, all these things need to happen upon first contact. I'm not going to presume to speak for DCF, but again, I want to make a presumption. I will say this: if we're not talking about criminal, we're only talking about DCF contact in non-abuse or obviously non-abusive situations. Would just have concerns from the point of view of my attorneys who handle sync cases, that upon first contact, all this information has to be provided. Even if it's a DCF worker who doesn't think they're there to work an abuse case or a sexual assault case, they're simply there to offer services and see what's going on with the family. Upon first contact, to have to provide all this information, maybe more than they even know that what they're investigating, what they're there for. I was asked to do a check welfare on a kid because I've seen kids running around. I don't see a parent there for large periods of time. So the DCF workers goes out to knock on the door and see what's going on. Upon first contact, when an adult comes to the door, they have to give this summary of the facts and summary of all these things. I don't know entirely what's anticipated there, but I think that would be very difficult to accomplish, and would set people up for failure in terms of, well, you didn't tell them everything you knew at the time. Well, I didn't know much. Again, I'll stay in my lane, but I don't know how to accomplish that goal in that moment. I'll also say this: Ed mentioned a moment ago that cops, at least from their perspective, don't want to share too much because they don't want to show their hand yet. They want to know what the person's going to say. I'd also say this: even if that's not the motive, and even if it's a DCF worker says, "Hey, we're just here because someone called in," there's also the risk there by saying too much. I understand it's supposed to be a brief and easily understood statement, but if this investigation turns into something and the kid ends up in foster care and I'm the defense attorney for the parents later, I'm going to say that you influenced with your statement, that your statement was designed to cause me to say something that later led my kids to be taken out of custody, or in the state's custody. I think we have to be careful about saying, even if it's well-intended, I didn't mean that, is not an answer that cops can get away with. And most of the time, DCF and other states' witnesses, I didn't mean for that to be taken that way, is not going to absolve us of claims that this statement either was intended to or inadvertently influenced the answers that were provided by the kid or the other parents. So be careful about that. The language issue I've already talked about. There are, depending on where you are, I think we can all safely say dozens of languages spoken in Kansas. Add in the dialects and the different variances, and it sounds like it could go much higher, which puts DCF at a real disadvantage. There's another thing that I think came up in earlier testimony this week on a related bill, not this bill, obviously, but I think it's something that I guess I didn't realize was misunderstood or not understood. And that is that DCF doesn't have, they're not cops. They don't have 3 shifts that work around the clock 7 days a week. DCF are 9 to 5 or 8 to 6 employees. They may have somebody who certainly works with kids that they have in their custody overnight if they need to be, or maybe somebody sits with a child in the hospital or something. But in terms of having staffing going out 24 hours a day, when a lot of these things are going to occur, again, I'll defer to Ms. Howard and the folks at DCF, but there's a practical logistical concern here to some of these things that upon first contact may be in the middle of the night, and that's gonna I'm not sure how DCF's gonna rise up to that or live up to that requirement. My written testimony, I didn't pull any punches. I thought I'd be just straight with you on what my thoughts are on this. There are new section number 3 I'm not sure what that's intended to be, but it's, if a kid's in the custody of the secretary, they don't need consent to get an examination. So I guess it presupposes that the injury, the damage that was done, the treatment that's necessary occurred while the kid was already in DCF custody. So if that's the case, then they are in this place of, they stand in the place of the parent with legal guardianship. So DCF could get its own waiver, I suppose. But I don't know. I think that's a difficult section to try to implement. And I am concerned, obviously, when it comes to abuse. And those are the kind of things when a child's been abused or claims they've been sexually or physically abused, they need to go in for an examination. And if we're going to say that the parent can say, nope, you're not allowed to do that, that's going to be problematic in terms of understanding and getting to the bottom of what may have happened to this child. I can't just go to a court and get a court order. I don't have a case on file. I can issue an inquisition subpoena under state statute and ask for business records and things like that. But to go seek a court order on probable cause standard in the middle of the night when I need to get this kid examined, that's not a real thing that's done in Kansas at this time. Brief here, section 5. I've got some concerns there that have been set forth. The probable cause standard, again, I kind of alluded to it in my comments just moments ago. And I would also point out that the new section 5, bottom of page 9, top of page 10, sort of interjects both probable cause and then a reasonable belief standard, and has 2 legal standards sprinkled throughout, which I think are somewhat problematic. I guess I'll finish my comments with this. I recognize there's been at least 2 bills now this week that have been worked. Both of them, in my opinion, seek to make some fairly seismic changes to the manner in which we protect children in this state. I have a better understanding after speaking to Representative Howard last night that that's maybe not her intent to do that with respect to at least to kids who have been abused or who are in imminent danger, that sort of thing. And we're trying to separate this out. But I will say that I think I'm not entirely sure where some of the information is coming from. I put in the last couple pages of last bottom of the fourth page, I guess, third page of my written testimony, some statistics from Sedgwick County. And we have 524,000 people in this jurisdiction. Got at any given time about 5 attorneys who do child needed care cases. In Sedgwick County, according to the statistics I was able to find on the state's website, about 25% of our population is kids under 18. So that's about 132,000 that are kids in my jurisdiction. Just last year in 2024, end of business, we filed 519 child needed care petitions on 301 families. There's 132,000 kids, and we're filing on 519. That is an infinitesimally small number of kids. If someone can tell me that can point to a single case in which we have taken a child because they were allowed to have too much screen time, or were allowed to play in the backyard unattended, or didn't have a nice enough bedroom, or enough nice clothes because mom's poor, and if that was the reason we sent it, I would encourage you to give me the case number, give me the example. We don't have time for that. The cases we have are abusive or habitually negligent, where kids, their lives and their health are at danger. We have a community that is very diverse. 61% of the kids get free and reduced lunches. 61% of that 132,000. 15 to 20% of the kids live at or below 100% of the poverty rate in Sedgwick County. And yet we only filed, again, this infinitesimally small number of cases. So my point there is not to sound defensive, and if I do, I apologize, but to say, if we are going to do a wholesale change to the child needed care code, number one, I hope it's based upon actual facts and not anecdotes that we've heard. When Senate Bill 367 was passed in 2016, and that's a sore spot for a lot of us, I heard over and over again about a particular anecdote. There was a child in a particular location somewhere in South Central Kansas, not Sedgwick, who was sent up to the reformatory because she had stolen a candy bar. And that was used as an example for why we needed these changes. This is the kind of madness going on in the courtrooms around the state of Kansas. So we reached out, our organization, to try to find out what the backstory was in this case. Is that true? Did it really happen? Well, it was true. She had gone in to a convenience store and stolen a candy bar, and she went up for that. But so that's a true statement. But what they didn't tell you the rest of the story was she was standing next to her boyfriend with a gun in the face of the clerk. And he was convicted of aggravated robbery. She was charged with it, but as an act of grace, because they understood that she was under the influence of this boyfriend. The prosecutor there afforded her the opportunity to plead guilty to the misdemeanor, but she had to be punished for what she did and the role she played in that crime. And so she did go up for the misdemeanor, but that was not how they handle misdemeanor shoplifting cases. And so my point is sometimes a true statement can be made, but there can be just to be blunt, a hell of a lot more context to the situation than may come at first blush. So I'm, like I said, I'm toning this down, and I get the motive here. I heard your comments to begin with, Representative Howerton, that you want the discussion. You want to make sure. I understand your motives here. You want to make sure that the kids who need the help are getting it, and the ones who shouldn't be taken out of the home are not. And we share that, absolutely. And if we can improve the manner in which we protect kids in this state by a longer ongoing discussion, we want to be a part of that. And if with this bill does a more distinct pivot to say this only applies to more benign interactions between DCF, not law enforcement, not cases where there is articulable belief that we're talking about a case of abuse or injury or harm that's at risk to the child. If that's not the universe we're talking about here, then there's, I think, probably some room to move and some ways that we could have further discussions about this. And I think on behalf of the DA's Association, I'm no longer on the board or the president, but I still have a lot of folks or friends over there. And one of my deputies in my office is on the board. I think I can safely say that we would be willing to absolutely be a part of that. In fact, we'd love to be. But we want to make sure we set some pretty bright guardrails moving forward. So I'll stand, I've said enough. I'll stand for any questions anyone might have.
Okay, thank you very much, Mark. I do appreciate your expertise and your experience, which is, I think, 30 plus years. Is that right?
Yes, ma'am. Yep. I did child needed care cases in 95, 6, 7, something like that. When I first got out of law school in Junction City, Kansas, where I worked there, and then came back down to Wichita in 97. I've been doing it ever since.
Yeah. Well, thank you. Thank you for your expertise and your participation and just your comments today. Is there questions, committee? You're going to let them off easy? Really?
Well, I see Susan sitting there. She's got to have some question for me. Right?
That's what I was thinking. Representative Humphreys, you have any questions for our wonderful district attorney?
Yeah, thank
I'm
you.
kidding.
Yeah, thank you. I guess it's not really a question, but it is, well, it's kind of a question. You said you'd be willing to work and maybe figure out how this could work out, because it's, as other things that we have talked about in other committees, there's two sides, and yet could we come together with something that would work for both sides? So if we could do that, that would be really great. Thank you.
Well, I'll leave you with this. Don't ask any other questions. My way of looking at these things is, and it sounds sarcastic, I don't mean it to be, but it's true. I'd rather be at the table than on the menu. So I will always be willing to talk to anybody to make sure that anything, and in all seriousness, a bill that impacts child protection in this state is something that matters a lot to me. So I will absolutely make myself available to help.
Okay,
or at least be in the room to say, please don't. So, yeah.
Thank you very much. And I did talk to him last night, and we are going to work on some amendments for this bill. So happy to do that. No other questions for him? Okay, are there any other opponents in the room that wish to speak orally? Okay, if not, we'll turn to neutral testimony. And first up is Secretary Howard. Okay, thank you. Welcome back to committee, Secretary Howard.
Thank you, Madam Chair. Thanks for the chance to speak to you today about the bill and to provide neutral testimony and to share some concerns we have. You'll hear some commonalities with some of the things that some of the opponents have said as well. You know, as a piece of context, you know, in recent years, you know, this legislature certainly has put some energy into trying to ensure that entities connected with the child welfare system understand kind of what their rights are. You know, you passed a foster parent bill of rights, passed a bill of rights for foster kids. And we've had a lot of conversation in a lot of committees about parents, right? And about, you know, how to best help parents understand what's going on in an investigation, how to provide supports. I mean, for example, we've done some projects at DCF where we even have some projects going on where there's some pre-petition legal support through Kansas Legal Services, things like that. So I'm very supportive of the parents of a child under investigation, you know, understanding what their rights are and understanding what's going to be happening. I mean, it's a very confusing process, I think, for families as we, you know, go into their homes, as we want to talk with them and their children. But we have concerns that the bill as written could actually really hamper or delay our ability to investigate abuse and could actually, you know, result in real harm for kids. I mean, so that's so as the bill is written, we are concerned about that. You know, in terms of I won't go over the summary of the bill. Jesse did a great job doing that, but I just want to talk a bit about our current practice and the parts of the bill that kind of cause us the most concern. You know, as you know, I mean, both the Secretary and law enforcement have the duty under Kansas law to receive and investigate reports of child abuse, to determine whether that report's valid, whether action's required to protect a child. In state fiscal year 24, we assigned almost 25,000 reports of abuse and neglect for investigation and further assessment, you know, after those had come into our Protection Report Center. You know, under state law and under federal law, what's called the Child Abuse Prevention Treatment Act, we're really required to provide, you know, immediate screening, risk, and safety investigations and prompt investigation of such reports, really making sure that we have procedures for the immediate steps that must be taken to protect the safety of a victim of child abuse or neglect, and just to ensure their placement in a safe environment. You know, when we go out today, and we attach this to your testimony, we provide parents with a brochure, and it says, you know, what you need to know about investigations of child abuse or neglect. And we've got this, I know we have it in English and Spanish. I'm not sure if we have it in some other languages. It's not specific to the allegations against the family, and I think you already heard some pieces related to concerns about that. But it certainly lets the parents know what some of their rights are, lets them know what they should expect during an investigation, tries to make it, you know, the whole process, I think, a bit more mysterious to them. And again, just to answer the kinds of questions that a family might have at the beginning of this process. So that's already our practice, you know, at DCF. I think we've been doing that. We were trying to figure out when we started doing that, and I think we started doing that in the mid-90s in terms of having this process to share that information with families and answer questions they have. So again, we think that's important, that's valuable, and again, just one way that, you know, I think it can just help families at the beginning of a process. You know, when we get a report of abuse or neglect, you know, assessment's completed, and you've heard us all, those of you involved in some of the child welfare conversations, you know, how much we really try to walk alongside the family, to have team decision-making processes, different ways in which to think about what the best next steps are for the protection of the child. You know, while some of the rights in this bill are really kind of consistent with that practice model, you know, the mechanism in this bill for advising parents of these rights, we think in many cases would create some real challenge in the ability to have that early engagement with the family and really kind of put up a wall. And so I think I'm just concerned in just at a high level about just the adversarial nature that the bill as it's written might connect. When we're really trying to build relationships, build rapport. So again, that's one just high level concern that we have. Again, the bill also, well, again, while we support the spirit of a Bill of Rights, it also can create some real procedural obstacles that could increase our response times, create confusion, and include processes that might be duplicative. For example, some of if a parent, pre-adjudication of a sync case, if a parent doesn't consent to a medical examination or to release of medical records, we would have to go and seek a court order. And you passed, for example, the care bill a few years ago that allows us to get some specialized review to really assess whether or not there is abuse or neglect by specialized pediatricians. This would delay those kinds of processes. I think it would also interfere, and I think you'll hear this from another conferee, with some of the multidisciplinary teamwork that we try to do today. I think the bill also makes it more difficult to comply with the requirements of Adrian's Law, which requires, visual observation of the child. And as Ed Klump noted, there's a language change in this bill that would require the secretary to visually observe the child as soon as possible. I mean, that's a fine language change, but the bill itself, by really calling out very directly the parents refusing the child to be seen without an attorney present, refusing to allow the secretary to interview the child without a court order. And there could be a lot of circumstances where we would not be able to see that child very soon, or as soon as we're being able to see that child today. So if we're denied access under this bill, a court hearing would be required, except in very specific circumstances. And then those circumstances, they're important circumstances, but as the district attorney said, I mean, they have sort of different standards of proof. Talks about probable cause, talks about reasonable belief in the same section, and really calls upon kind of my staff to have to kind of make those kinds of determinations. So again, I think the necessity to go back to the court to have access to records to the child, I think would delay investigations. And again, for those children probably most at harm, those are probably the circumstances in which that's actually most likely to occur. And I think I might just make one comment about the attorney piece too, because, in the bill, the sort of the right to have an attorney appointed would only happen in cases of indigency, and then also if there's already a petition being filed. So again, you could have a lot of circumstances where, you're really waiting for the circumstance for a family to, figure out how to secure that attorney and those things. And again, so my big concern is really the delay in the ability to conduct those investigations, keep the child free from harm. Our fiscal note, in fact, is really about more attorney positions, is what it really comes down to, because I think the passage of this bill would require us to be, seeking action by the court very early in investigatory processes, either to seek access to the child or to seek access to necessary medical records or to make referral for medical services. One of my attorneys made a call to, kind of the Texas Department just to kind of try to get a sense. And this hasn't been in effect that long, so there's not a lot of feedback yet. But I think what the attorney down there said was, we're spending a whole lot more time in court, in order to, secure that access, see the child, find records and the like. So again, we really agree with the intention of making sure that parents and families, when they come to the attention of our agency or an investigation is beginning, that they understand what their rights are, that they understand the process and what's going to be happening to them. We just think the legislation as written could have some really harmful effects and really go against its intention. So I would stop with that, Madam Chair.
Thank you. Questions for the Secretary?
And we'd be happy to work with you as well, going forward.
Of course. Thank you. Representative Humphreys?
You may have addressed this right here at the end, but I noticed on the fiscal note that you had said you thought you would need 6 more FTEs. And that would be I was thinking it's attorneys. Is that what?
Yes.
Because there was going to be more litigation, or tell me a little bit more about what you were thinking there.
Sure. Yeah, really two parts to our fiscal note. One is we think we would need an additional attorney in each of our 6 regions. So that we would have an additional sync attorney. And again, really going back to, that context that we would expect to have far more families sort of refuse access for interviews or investigations, or to see the child, or to seek, medical care kind of pre-petition for a child. And so we think we would need more legal support to go back into court to seek those court orders. The second part of our fiscal note is more a piece. I didn't really speak to the language issue. I think others have spoken to that, just that we would probably need some additional funding related to document translation and things like that if we needed to do every language. But our larger context is we really think we'd be spending a lot more time in court at the front end when we really need to be doing the investigation promptly and making sure children aren't being harmed.
If you would remind me, how many attorneys do you have now? I mean, I know some of them are here centrally in Topeka, but do you have attorneys in each of the 6 of your districts, and around how many?
I don't know the total number right now, but we do have attorneys in each of our regions. I mean, we do have sync attorneys in each of our regions. And
Or like 10?
let me ask. No, not like 10. So do you know how many? Yeah, we can get that back to you, Representative, in terms of our totals. But
how much more of a lift this was compared to what you're doing now? So thank you.
Sure, happy to do that.
Representative Neighbor?
Thank you, Madam Chair. With as many components as are in this bill, including the law enforcement and DCF and this committee, who was at the table to discuss this bill so there was some cohesiveness and input and stuff, so that maybe some of the language could have been changed in the original, or concerns could have been addressed?
So like I said before, I took this bill from Texas and I changed a little bit and I put it into the committee so that we could discuss it and we would be at the table.
Okay, so none of these other groups have been brought
No,
before today?
no.
Okay, thank you very much.
Representative Owsley?
Thank you, Madam Chair. And just along those notes, this was discussed in the Reimagine Child Welfare as well. So though the text of the bill wasn't specifically addressed, the concept was.
Thank you, Representative Owsley. Anyone else for Secretary Howard? I have a couple questions. So I'm curious about the pamphlet. So when you, and the process that you use, when you give that to a family, does anyone go over that pamphlet with them, or are they just handed the pamphlet in the midst of their?
I asked that same question, Representative, and I'll stand here honestly and say I don't know if in every circumstance, that's gone over with the family. I mean, to me, that would be a practice issue. I mean, in order to ensure that that we're doing that fully. So,
Okay.
yeah, but I can't guarantee to you today that that's happening.
Okay, and then my other question is, so we are, like you mentioned before, we have a foster parents' bill of rights, we have a foster child bill of rights, but there's not a lot of attention given to the biological parents. And that's kind of part of the reason that I think we as the Oversight Committee and I feel like we should be having this discussion today. What rights are new in this bill to parents? Are we creating, because it was my understanding we are not creating any new rights.
Thank you for the question, Representative, and we'd be happy to maybe try to do a little bit of a side-by-side piece. Right now, statute does not does not have specific provisions, in the sync code that call out those pieces. Many of the things that are within this provision are things that we certainly let families know and that are included within our brochure. But, when you get into the details of, say, things like, letting them know all of the allegations that are against them, some things like that are included within this, I think that's where you can kind of really get into some concerns. And again, Jesse may be able to help as well with any comparison to current law. Yeah.
Jesse.
Sure. Jesse, Revisor of Statutes Office, I think in providing information about processes, that's not necessarily the creation of a right. So you have to separate the information to be given versus what may be allowed in statute or in customary practice. So for example, when we talk about the right to counsel is covered under 382205. That language talks about when a child is alleged or adjudicated and talks about the filing of the petition. But so that in itself is not a new right, and this bill doesn't say a time, so that doesn't necessarily conflict nor create a new right. So that's an example. Everything such as recording, that's already allowed in statute as well.
Thank you. So I guess my concern is, and this is the question that I've been trying to ponder with this bill, setting aside child abuse and what Mr. Bennett talked about, those extreme cases where police need to be involved. And you have the other side of that, where are we infringing upon biological parents' rights? Because they do have rights. And so trying to find that balance for Kansas is kind of the premise behind that. Do you have any comments on that, Secretary Howard?
No, I understand where the legislation is coming from. I think the challenge, though, comes sometimes where, the ability to discern that harm, sometimes is the result of being able to conduct the investigation. And so, when we start out in every investigation, we don't always know, for example, that we think this is going to end in something criminal or that it's a situation where we need to involve law enforcement. I mean, part of that happens during the process of the investigation of interviewing the child, seeing the child, interviewing the family, interviewing others. And so I think that's part of the challenge in putting in place pieces that would impede that at the front end. I mean, I think that's the concern that I have. I mean, in terms of the support for families, I've talked for a long time in this work just about, the fact, and I think this has come up a lot in the conversation about, parents' attorneys where, kids have guardian ad litems. I had a friend a few years ago that worked for a child welfare contractor, and she was always like, where's the FASA? Where's the family appointed special advocate? Who helps the family? And so I think, I totally am in support of, how do we help to provide families with tools to navigate this process? I'm just concerned that the way the bill is written right now, that it creates both such an adversarial piece up front and also sets up too many procedural barriers that we just think would delay investigations and create more potential for those children who are most at risk for harm. So again, happy to.
That as it's written right now, and so we're trying to find what is best for Kansas. So do you have any comments on that?
I don't know that I have specific detailed comments now, but we'd be happy to work with you on what language might work, those sorts of things as we would move the process forward. So we'd be happy to sit down with you. Yeah.
Yes, that would be great.
Thank you.
Any final questions for Secretary Representative Howell? Welcome to committee, by the way. Thank you for substituting today. She is on the joint oversight committee with us as well. So,
thank you very much, Chair. Thank you, Secretary Howard. Since I am not normally here, if the chair give me a tiny bit of latitude here. So you, Secretary, you have mentioned the upon first contact and some of the other conferees have also. It just occurs to me, if we were to offer some latitude on or an alternative time for giving that information, do you think that would be possible, that would help make you feel a little more comfortable with that? at, presenting those parents' rights, if it didn't have to be, immediately. And I'm not necessarily asking that you would have to give me a firm answer right this moment, but you think that would be a possibility that would help, I guess.
Yeah, I'm not sure, Representative. I'd have to give that some thought. I'm not sure if that would make a difference in that context. I mean, let me think about that. I don't want to just speak off the cuff without giving that some
understand
thought.
completely.
Yeah.
Just a slight comment, and I know it's a hearing, not working the bill, but I know I get calls from parents who have a visit from DCF, and I know we all do, and they just panic because they're just scared that their kids are going to get taken away. And I know because of personal relationships in Sedgwick County, where I live, I know the goal is, if at all possible, to keep families intact and to not remove children. And I believe that is the goal because I know so many of the people that are working in Sedgwick County and DCF. So I can speak with confidence to these parents that call me when they have that are panicking and scared, okay? And I can say to them, if you aren't abusing your children and if you aren't endangering your children, you can with confidence open the door and let DCF in because their goal is to just make sure your children are okay. And their goal is to protect you and your family and to help you and be assistance to you. And so I would just like to suggest that maybe one of the things we should consider for this bill moving forward is to have a statement as part of these parents' rights. Is what the goal of DCF is to protect families and to help families if it's possible and safe for the children. So just a thought.
Thank you, Representative Howell. Representative Owsley.
Thank you, Madam Chair. And I think Representative Howell just kind of explained that any interaction with DCF can be traumatizing in and of itself, whether you're, answering the door or find a pamphlet on the door. But you mentioned that you didn't, a large hesitation with this was the delay of investigations. So what if currently, somebody is an informed parent, knows that, oh, this is bad, DCF's knocking on my door, and go ahead and attorneys up today prior to answering any questions, wouldn't that already delay investigations?
That can happen once in a while. It doesn't happen that frequently today. I think our concern with this bill is if you're starting out and you're telling a parent, the pamphlet says you don't have to talk to us. Our pamphlet says that, right? But if we're going further and saying things to the parent, like in this bill, that if you talk to us, anything you say might be used against you in a child in need of care proceeding or in a criminal proceeding. Some of the specific pieces. We're all sort of taught, right, with the Miranda rights. Okay, I didn't do anything wrong, but I'm going to be quiet. And so I think it's that context, right, where we worked really, really hard to kind of create a model of walking alongside families, knowing what it's like for a family when we come to their homes, creating kind of that practice model that some of you know so much about where, as we do those investigations and as we think about what does safety for this child look like, who comes around that table, who's, the family, who's close to the family, who's close to the child, how you really how you can work as a team in many circumstances. And I think I just have concerns that this would really interfere with that to a far greater degree than what happens today.
So I just think back to the Judicial Summit and the lived experience panel. The people that were on that panel, the theme of it was, I wish I had more information up front. It could have changed the entire trajectory of that family and their experience. Thank you. Thank you, Madam Chair.
Thank you, Representative Owsley. Any other questions for Secretary Howard? Okay, thank you very much. Okay, next, welcome to committee, Crystal Hedrick. You're the next contestant. Thank you.
Good afternoon, Madam Chair, members of the committee. Thanks for letting me be here today to speak regarding HB 2175. My name is Crystal Hedrick. I serve as the CEO at the Children's Alliance of Kansas. Members of our alliance work in many ways to support effective parent engagement strategies with all parents across the state, birth parents, foster parents, kinship parents, adoptive parents. And so we haven't talked a lot about the scope of this bill in terms of outside of birth families. And I think that's because some of the intent is that this would be a bill of rights for birth parents experiencing the system. But just if we can lift that up and keep that in mind as we're working through this. We really appreciate the concept of HB 2175. It's important that families understand and have clear and concise communication when they're experiencing our system in any capacity, because it's confusing, even for those of us here who have these types of conversations frequently. We did hear testimony earlier in the week about the existing rights of parents in relationship to their children and how those rights can sometimes become unclear or murky when we're trying to ensure child safety, because that does feel different and that does have a different sense of urgency for us when we're approaching those situations as professionals. It would be helpful to have a compact statement and standardized language around this so that we could ensure that families have the information that they need when they do have that knock at the door and things feel scary. That way they can also advocate for their child if perhaps they are not the alleged perpetrator in this scenario. So they can also just help their families navigate any challenges that they might be experiencing. That being said, as many people have noted here today, that there's some components of the bill that go beyond that initial notification. We'd recommend that we continue to allow the experts in their respective fields to come up with policy and procedure to implement a statement of some sort in a way that works well for them and does ensure best practice. The Joint Committee, there's a senator on the Joint Committee that has talked a lot about this issue in particular over the years that I've been here in this space, and just sharing the concern that do parents really know what is expected of them? And I think that this aligns with that too. What do you need to do to keep your children with you safely? So that could be a component of this in terms of a Bill of Rights for parents and them understanding what the situation in front of them. So we are encouraged by the efforts of this committee to elevate the rights of parents across Kansas and to really prioritize that communication. And I'm happy to stand for any questions.
Okay, questions, committee? Any questions? That was very concise. I appreciate that. Okay, no questions. Thank you. And last we have Casey Dalkey. She is on WebEx. Casey, are you there? Are you muted?
I am.
There
Can
you,
can
there you
everyone
are.
hear me?
Yes. Thank you, Casey. Welcome to committee.
Thank you. Good afternoon, Madam Chair, members of the committee. I am Casey Dalkey. I serve as the Executive Director for Children's Advocacy Centers of Kansas, representing a statewide network of 18 children's advocacy centers. And our mission is to reduce trauma for child victims of abuse and improve system responses through multidisciplinary team collaboration. So I come before you today in a neutral position for House Bill 2175. We appreciate the bill's intent to strengthen parental rights, but also want to ensure that any modifications to the child welfare policies do not unintentionally delay interventions or obstruct child safety measures. Kind of as we've heard throughout the calls today, or throughout the testimony given today already, we fully support parental rights and transparency in child welfare investigations, but do urge the committee to carefully consider the impact on child victims, especially in cases of child sexual abuse and severe physical abuse or neglect. And these are the cases that come through our doors here at CACs, and therefore that's the primary lens in which we are viewing the bill as it's written today. So I did have some areas of concern or question, if you will, that I wanted to bring to the committee, and I have that outlined throughout my testimony, but just to touch on a few. When we're talking about timely interventions for children in immediate danger, how can we ensure that House Bill 2175 does not delay emergency interventions in cases where a child is in immediate danger or sexual abuse or severe physical abuse or neglect is present? while balancing parental rights with urgent child protective measures. Would the committee consider additional safeguards to ensure child safety remains that top priority while protecting parental due process? Emergency access to children in high-risk situations without a court order. Could we consider allowing emergency access to children in these high-risk situations, particularly when child sexual abuse is suspected, without requiring that order? And then ensuring the multidisciplinary teams can work effectively. Could we clarify that multidisciplinary teams, including CACs, could continue to have access to children and critical records without unnecessary procedural delays? Along those delays, as well as streamlining court involvement to prevent delays. Could the committee explore expedited court review procedures for cases where parents do deny entry or potentially obstruct investigations? And then just to add a little bit of clarity around the medical examination and access to medical exams, should medical exams be allowed without requiring a court order when reasonable suspicion of specifically sexual abuse exists? I mean, when we're talking about severe physical abuse, oftentimes that reasonable suspicion can be seen just by laying eyes on a child, but child sexual abuse is so much different. There are generally no signs that would give us reasonable suspicion, and so just ensuring that there's safeguards in place again for some of those extreme cases that we see that you've also heard other testimony pieces on today. And to help us do these things, I do have some proposed language in my written testimony that suggests fully defining specific instances. For example, defining imminent danger. Could the committee consider defining imminent danger to explicitly include ongoing child sexual abuse, exploitation materials, or coercion preventing potential abuse? And then how could we look at expanding the definition around high-risk situations? I've got some bullet points listed in my written testimony, but again, is to include prior substantiated child sexual abuse cases, prior situations where there was caregiver obstruction in interviews, or multiple situations where multiple children in the home and one of them had disclosed. So that was just kind of a quick rundown of the pieces that you're going to see in my written testimony. And we certainly do appreciate this conversation today from all the conferees, but also appreciate Madam Chair's openness to this discussion and recognizing the committee's dedication to both parental rights and child safety. And we strongly believe that through thoughtful amendments in this bill, we can ensure that while parents' rights are protected, no child is left at risk due to procedural barriers as well. So we certainly welcome collaboration with the committee to craft a future bill language that accomplishes its intended goals while prioritizing child safety. So I thank you with that for consideration and hearing my testimony. I'm happy to stand for questions at the appropriate time.
Thank you. Committee, are there questions? Y'all need some caffeine? Any questions? Okay. Yes, ma'am.
Sorry.
Representative Page.
Thank you so much. My still concern is the financing of this because of some of the cuts that will be coming down pretty soon. And I've heard a few people say that's not an issue, but with all we want them to do, that is going to be an issue. So I hope this committee may not handle that part, but that should be brought up. We want a lot, so how do we pay for it? And with one part of our tax base saying, hey, cut taxes, another part saying, let's do something, we got to do something, trying to find that happy medium.
And I think with what we've heard today, we'll have significant amendments on this, and so that may not be cost. The cost may not be an issue, so we'll have to see where we end up, and then we can have that discussion, I think. Would be good. It is important, yes. Any other questions? Representative Owsley.
Not a question, just a comment. The representative raises a valid point. In appropriations today, we approved or adopted the committee report on the DCF budget, and there wasn't even a mention of the governor's budget recommendation for the $8 million in the the executive order to stop with the SSI going to compensate for kids in care. So valid concern to raise.
Thank you, Representative Vousley. Any other questions? Okay, is there anyone else that would wish to testify? Okay, well, I appreciate everybody's, all the conferees' commitment to work with us. We will be working this bill on Wednesday to see if we can come up with a way forward for Kansas. I think we can. We've got a lot of smart people in this committee and a lot of smart conferees. So with that, I'll close this hearing. And I'm going to reopen the hearing on HB 2075. And first, I'm going to welcome, do you have a preference on Crystal or Carrie? Okay, Crystal, if you want to come forward, she's just going to present some information on questions that we had during the last hearing. Maybe just refer to what you sent us and.
I didn't know I was doing this.
Oh, I apologize.
That's okay.
Okay.
So what am I talking about?
The information you sent us on the questions that we had.
I think the information I sent you was just regarding, there's like 4 other states, sorry, Crystal Hedrick, Children's Alliance of Kansas. There are 4 states that offer child-specific ages in terms of when they hold permanency hearings. But primarily states that have implemented more specific court requirements around the age of the child, they have specific court systems for that have an entirely kind of separate programmatic component to them, like baby court. There are some states around us that do things like that. So there are some states that have done that. It would be more of an administrative component, and then we would have to consider if the child's a part of a larger sibling group, what does that monitoring look like? But mostly in situations where courts are treating the age of the child, treating the court case differently, there's an entirely separate court system and process that would take place in that scenario, which would be kind of a whole nother conversation.
Okay, thank you very much. And then Carrie Larnard, if you want to come, just quickly go over your information as well, that would be great.
Good afternoon. Carrie Leonard, Office of Child Advocate. Thank you, Madam Chair and members of the committee. Just, I think, to build off of what Crystal Hedrick had just shared, and the chair had requested when we were here last time if I could provide some additional information, particularly around some of those questions around those specialty courts. And so I did, and I don't know if everyone has this now on your drive, but did submit just some additional information around the infant toddler court programs. So I think what Crystal had shared was that there are some courts across the nation who look at different ages, but then in particularly in looking at the different needs of younger children. There are some court models that specifically address infant toddler and those needs and thinking about child's time. As we had talked about before, younger children, and when we think about child's time, looks very different than our older children who might be 13, 14, 15, 16-year-old. So in there, I think the biggest thing to think about is that it really is a specialty court model. So it's just not around setting a permanence hearing that is specific as to the age of the child, but really it's a wraparound service model. And so that's something that our state, if we were going to consider looking at a different timeline for younger children in particular, that we also need to really be looking at what those additional services would be that would need to be wrapped around that family.
Any questions? It's very interesting. I was really curious how they did it, so I appreciate both of you digging into that. Any questions? Okay, and then to answer the last question on HB 2075 was about the courts and the effect it would have on that. We have a neutral testimony coming in from Chief Judge Nicholas St. Peter. Are you online?
I am.
Great, we can hear you. Thank you.
Thank you. Thank you for the opportunity to address you today. And I know you're probably anxious to get out and start your weekend as well, so I'll try not to take too much of your time. Chairperson Howerton, Representative Johnson, Representative Owsley, thank you for the opportunity to talk with you today. I know you've read my written testimony already. Again, I'm Nick St. Peter. I'm a district judge in Winfield. I've been a district judge for almost 21 years, and during that time, I have always presided over child in need of care cases. Prior to being a district judge, which does not appear in my testimony, I was an attorney in private practice for 19 years in Winfield. During that time, I also handled child in need of care cases, both representing parents and being a guardian ad litem for children. So I have about 40 years of experience within the system. And obviously during that time, I've seen a lot of changes within the system, including, the law, the move away from DCF to the contractor system that we have now, and more use of evidence-based practices in what we're doing as judges, the training we have as judges in working with families and children. I've also observed the kinds of cases that we have in our courts as changing very dramatically in that time frame. I think the cases that we see in our courts now, and actually I think District Attorney Mr. Bennett kind of referenced this in his testimony on the prior bill, is that the cases we're seeing now are much more severe, much more complex in terms of the needs of both families, parents, and children, and much more complex in the amount and the number of services and the kind of services that we need to have in place to have a family successfully work a plan of reintegration, which is typically the permanency goal as we start in these cases. In my testimony, I referenced two terms, permanency hearings, which are a legal hearing, as you know, where the court is determining what is our goal. Is our goal reintegration? Is our goal some other type of planned permanent placement for this child? Is our goal going to be adoption? What are we working towards? Those initially begin really at the beginning of the case. The social workers are working with the family and the attorneys and the guardian ad litem to try and ascertain what that goal is going to be, and then also to ascertain what that plan is going to look like. What kinds of services does this parent need in order to be successful in being able to safely have that child return home? Oftentimes in the cases that I think we see in courts, that involves evaluation for substance use disorder, evaluation for determination of level of treatment that might be needed. That might mean screening for mental health issues as well, and determination of what services, if any, would be needed. And those can not only include the parent, but also the children who may have been in a situation where there has been substantial trauma that they have endured that needs to be addressed before they can be successfully returned home. With that, then we have review hearings, at least in my court and most judges that I talk to, pretty much on an every 90-day basis, if not sooner. And when we're having those hearings, we are talking about what is the permanency goal. We're talking about what progress has been made by the parents. What are the needs that still remain for us to continue to work towards that goal? So what I want the committee to understand is that even though we may only have a permanency determination once every 12 months, as required under the statute and federal law, we are considering the issue of permanency every time we touch that case, and considering what the progress has been made towards that goal. In terms of the change in the law from 12 months to 9 months, I think from the court standpoint, as long as we have enough notice about the change so that we make sure that we have it within our tickler systems to get notice of hearings out, because we're required to give 30 days advance notice in writing to all interested parties before we hold a permanency hearing. As long as we have the ability to react to that, I think we can certainly meet the requirements of the change of statute without any issue. I think my overall arching comments and the comments I heard from other judges as I prepared this testimony, however, is that I don't think that we want this committee or the legislature to think that simply changing this goal is going to, in our view, dramatically impact the number of days that children are actually in the foster care system. And the reason for that is because that doesn't change the actual application of what things are happening on the ground day to day in these cases. As I said, oftentimes parents, if they have a substance use disorder that's serious, and many of the cases we see now, parents do, that's not something that we can remedy overnight. That takes not only treatment, but working long-term plans of recovery. Many parents have co-occurring disorders, mental health issues. They need to get access to services. Sometimes the wait list for people to get access to services are long and not immediate. Also, our contractors work with our parents. We've had instances, I know, in our district and in others where there's been a great deal of turnover of staff that are working with those families. So you imagine you have, the caseworker and the parent partner that are assigned to that parent that are working with them, and they work with them for 3 months, and then they leave that position and go somewhere else. And then we have somebody that's in kind of on a temporary basis until someone new is hired and trained and replaced. So all those things kind of build in some level of delay, I think, in being able to achieve permanency in a much quicker fashion. So the point being that we could certainly handle this within the court system. Don't necessarily disagree with the aspirational idea that we need to find permanency quicker for kids and families. But we have to also be realistic that we don't know that this is really going to move the needle a whole lot in terms of what the outcomes are. So I appreciate the opportunity to speak with you. As you can see within my written testimony, I've been a drug court judge for almost 16 years. We're piloting one of the family treatment courts that we started in September in our district, and I'm the presiding judge of that. I've handled care and treatment cases for all the nearly 21 years I've been on the bench. I preside over an assisted outpatient treatment court and have for about 3 years now. So through that, I've gained a lot of experience in working with individuals who have substance use disorders and co-occurring disorders. And it's kind of from that experience that I feel like I can say that these things just take a lot of time. And, if we return children home, what we want to know is that they're not going to come back. We want that to be a permanent placement, because every time a child is removed from a home, that's another trauma for that child. And I'm sure you all have heard and understand the concept of ACEs. The more children accumulate those, the greater likelihood they are to have their own issues as an adult. Obviously, we want to stop this cycle of things repeating themselves over and over again in terms of families. So with that, I'd be happy to stand for any questions that you have.
Thank you so much, Chief Judge, for taking the time to answer that question. I really appreciate it. Are there questions, committee? Did that answer the questions we had? Okay. Okay, so I'm going to close that hearing and just let you know that the minutes from 2.3 and 2.5 will be on the S drive next week. We'll be looking for motions. We are going to work this bill, the 2075, on Monday. We do have a presentation from Casey family, so we'll have that, and then we'll work the other two bills on the definition of neglect and the 2175 we heard today on Wednesday. And then Monday, I just want to give you a heads up. We will be hearing the last bill that just got assigned to us yesterday. And I'm just giving you a heads up because we're going to have to hear it, and then we're going to have to go to emergency action and work it the same day, because Monday is our last day to hear bills. Okay, and that is going to be, does anybody have that? Here we go. It is HB 2311. So be thinking about that, read that. You've got a week from Monday to do that. Be thinking about it, have your amendments to Jesse, and then we will hear it and probably go into emergency final action on that date. The conferees were not available on this Monday, so that's, or Wednesday. That's what we're going to have to do. Okay, any other questions? Have a safe weekend. Go Chiefs. Thank you very much. We're adjourned.